Hello, everybody. This is a really important discussion for self-directed IRA investors. Anybody that's got property and they use their IRA to make that investment. And the question is, can I hire myself to work on my IRA properties, right? So very often you'll see an investor that also has an income source that is like they're a broker, so they've got brokerage fees, or they're a painter, a property manager, a landscaper, any type of trade that could be affected by real estate. And you ask, can I use my professional services to benefit my IRA property? And there's a lot of confusion and a lot of disputes about that. I'm going to cover it and why it's so confusing here in this video, because it's really up in the air. And there's a lot of misinformation out there, and there's a lot of fear running through the industry telling us what we can and can't do. So here's the facts. There's two cases that are controlling this whole area. The first is the Etter case, decided in 1992, and then another case, the Rollins case, decided later. We're going to talk about that. Basically, Etter said if there's a prudent investment, if it's objectively a good deal for the IRA, or it's a better deal for the IRA, then it's okay to have self-dealing, no prohibited transaction. So if you, as long as you're not enriching yourself as an investor by having your IRA hire you and pay you above market rates, or say you're a realtor and the normal fee would have been 5%, you took 10%, right? That would be improper. Or if you're a painter and you would normally bill $10,000 for something and you build your IRA 15, that's not fair, right? So it's improper. So no, that would be not a good deal. But if you're giving the IRA a good deal, you're providing a low-cost service, or maybe even free, then that would be prudent as the manager of the IRA to get the best deal that it could. It's like buying something on sale. So if you go out and get your IRA a good deal by hiring your own service under the Etter case in 1992 going forward, that was good. Then it's important to look at Etter because it's a federal Seventh Circuit Court of Appeals reported decision. That means it's got the highest authority of precedent available under the law, and it's never been overturned. The only thing higher would be the United States Supreme Court. Okay, so Etter has never been overturned. I'm going to hold you with that. Fast forward to the year 2004 and the Rollins case. Rollins said, wait a minute, we don't care about your good intentions. We don't care about what a good deal it was. We don't care if it was a prudent investment. We don't care about any of that. If there's any self-dealing at all, it's prohibited, and you're going to pay a penalty. We can disqualify the entire IRA. You're going to pay not only taxes for all the time that it's in there, but it's a distribution, and you pay penalties on top of it. Bad, 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 right? A disaster. So Rollins took the Etter decision and just totally threw it out. And ever since 2004, we've been listening to pundits and our third-party administrators, all the different companies that provide these IRAs, and they've been saying no self-dealing whatsoever, right? Well, guess what? The Rollins decision in 2004 is what came out of the tax court, first of all. Guess what? The tax court doesn't want to give us a break. So that's number one. Number two, the tax court is a trial court. It is not a court of appeals. So it's not as high up as the Seventh Circuit decision that's come out. So it's below that, right? So it's a lower court. It's trial court. It's not even precedential authority because it's not a decision of an appellate court. We only look at appellate decisions for what the law is. We never look at the trial court level. So it's really, Rollins is kind of wiped out. Then, get this, Rollins is not a reported decision. It's called a memorandum decision. So lawyers receive in our email strings and our advance sheets all the cases that are coming out, and the court makes a decision, and it gives an opinion. It writes it up and says, here's what's the law, here's the law, this is what we're deciding. But guess what? This is a memorandum decision. It's not reported, which means it does not have precedential authority. So not only is Rollins a little old trial court, albeit the tax court big time, right? Don't mess with the tax court on the one hand. On the other hand, it's only the tax court. It is not a reported decision, and it's not an appellate decision. So the earlier case we talked about, the Eder decision, is a trifecta. It's got it all. It's a reported decision. It's a court of appeals decision, right? It's got everything. So the real authority, if you stood in front of the United States Supreme Court and said, what's the legal authority? You'd say the law is the first case, doing a prudent investment, making a good investment decision for your IRA. That's the law. That's the real law. But we've got this wild card over here in the Rollins case down at the trial court level that we're all worried about. So everybody's trying to make sure that we don't do anything wrong. And as the most conservative possible result would be no self-dealing whatsoever, no matter how good the deal is. That's the legal advice that your lawyer would give you. You'd say, hey, you can rely on the Court of Appeals, but here's this trial court decision, and another court might follow that. Even another appellate court might follow it and wipe you out. They might overturn Eder, right? So we don't really, we don't know for sure. We don't have any other Court of Appeals decisions on the issue. We don't have any Supreme Court decisions. We don't have any follow-up court opinions that address this idea of a prudent investment or an objectively reasonable financial transaction and whether or not it's prohibited or not. So Eder has been decided on these other things, has been cited on other issues that are not related to that. Rollins has been quoted, we call that referred to or cited in other aspects of the case, but not this prudent investment thing. So we've got a quandary of risk for us self-directed IRA investors. You got to be careful. So the real law that's reported by the Court of Appeals, the Federal Court of Appeals for Indiana, 7th Circuit, is this prudent investment idea. Below that, you've got Rollins. Maybe it's a trap door. Maybe it is going to be the new law. It's impossible to know. Nobody wants to litigate it. That's why they're going to this other most, extreme, cautious, conservative approach. So I know that's confusing, but I wanted to set the record straight of why there is confusion, why we're hearing these different things in the market. And oh, by the way, we don't know why Eder or Rollins initiated their appeal. How did those cases even get started in the court? Why were they triggers for audits? We don't know, right? The case does not tell why that happened. So that creates more uncertainty for us to try to advise you of which way do you go on balancing your transactions. So I want to give you that. It's important. The Eder case, the Rollins case. We'll talk more later. Thank you.